Good evening, guys. Good evening, guys. I hope you can hear me and you can see me also. Good evening, Manisha. Just do let me know if I'm audible and if I'm visible. Good evening, good evening, good evening. Good evening, Pramod. Good evening, Kashish. Good evening, Manisha. Okay, and I think I just increased the resolution of my video, so I guess this would be better now. Okay, okay, okay. Okay, so let's just start with it. Just a second. Okay, so better than last one. Yeah, I just changed the settings. I did not realize that what was the problem. Then I realized that the problem was that my streaming software setting was a problem. So yeah. So when you told me, if you would have told me yesterday, I would have checked it out yesterday only, but I wasn't aware. So I just realized that's the problem. Chalo, anyway. So so good to see all of you so much in energy and form. I want the same energy throughout your foundation exam. I want the same energy when you're writing your, foundation paper and obviously my paper. Okay. So we'll start with the questions. Direct questions are comparatively less, and as I already, I've already discussed scanners with you all, the Swiftscan. So I'm not going to go too much into the direct questions. So when a company is registered, and obviously if you have any doubt in any of the question, even after I explain it, you can please ask me. Just drop a message that you want me to explain it. You can just ask me, and we will discuss. And I would want for each of the question the case study. Okay, I want for each of the case study that you will actually give me the answers when I've read the question. Before I discuss the answer, I want you guys also to message the answers, right? So that you are in the, along with the class. You are, when a company is registered, it is clothed with a legal personality. Explain. So basically here they are talking about the separate legal entity concept. So we know the moment a company is incorporated, a separate person comes into existence. This is the company, and its existence is different from its members. A thin wheel called the corporate wheel distinguishes the company and the members. And such a person is capable of owning property in its own name, capacity to sue and be sued, and and holding property, and have a separate legal entity and limited liability, and yes, also perpetual succession. ABC Limited is a private company having 5 members only. All the members of the company were going by car to Mumbai in relation to some business. An accident took place and all of them died. Whether existence of the company has also come to an end? No. Company and members are different. The end of the company does not mean the end of the end of the members does not mean the end of the company. And if you remember, in class we discussed the verdict of the judge. The words he used was that even a hydrogen bomb cannot kill a company. If you remember that, yes. So no, company is absolutely, totally, and as much as possible alive. Now examine the following whether they are correct or incorrect. I want answers from you guys also. A company being an artificial person cannot own property and cannot sue or be sued. False, because company being an artificial person, yeah, it has perpetual succession. The previous question, yes. A company being an artificial person actually has a right to what you say actually has a right to own property in its own name, and the company can sue and be sued in its own name. A private limited company must have a minimum of 2 members, while a public limited must have at least 7 members. Correct. This is absolutely true, right? This is absolutely true. Examine the following whether they are correct or incorrect. A company, we already discussed this. A private, we already discussed. A fixing of common seal on company's document is compulsory. Well, it is not exactly compulsory, because as of today, after Companies Amendment Act 2015, in fact, it is not even mandatory for a company to have its own common seal. So if a company does not have a common seal, how will it even affix it? So no, this is not true. This is false. It is not mandatory. Mr. Raj formed a company with a capital of 5 lakh. He sold his business to another company for 4 lakh. For the payment of sale, he accepted shares worth 3 lakh. The balance 1 lakh was considered as a loan. Director, I'm sorry, did I miss out something? Oh, yes, 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 the signature. I thought, did I miss out on some question? Yes. If the company does not have a common seal, the document shall be signed by the director and the company secretary of the company. The balance 1 lakh was considered as loan, and Mr. Raj secured the amount by issue of debentures. His wife and 3 daughters took 1 share each. Owing to a strike of the company, just a second, my laptop will does not have charge. Let me put it on charge. Just a second. So Mr. Raj formed a company with a capital of 5 lakh. He sold his business to another company for 4 lakh. For the payment of sale, he accepted shares worth 3 lakh. The balance 1 lakh was considered as a loan, and Mr. Raj secured the amount by issue of debentures. His wife and 3 daughters took 1 share each. Owing to strike, the company was wound up. The assets of the company were valued at 60,000. The debts due to unsecured creditors was 80,000. Mr. Raj retained the entire sum of 60,000 as part payment of the loan. To this, the other creditor objected. Their contention was that a man could not own any money to himself, and the entire sum of 60,000 should be paid to them. Examine the rights of Mr. Raj and the other creditors who will succeed. So this is basically on the same line as the case of Solomon versus Solomon and Company Limited. And we already know that the moment a company is incorporated, company and members are separate. And as a secured creditor, Raj is entitled to receive the whole money himself, right? So, I mean, the 60,000 he can retain. So, Mr. Raj has a right to keep the money as a secured creditor, right? As a secured creditor. Raj will succeed. What about the other creditors? The other creditors will actually not have any rights at all. This is the same case as Solomon versus Solomon and Company Limited. You can in fact make a reference of the case also if you remember. Mr. Sunny sold his business of cotton production to Cotton Production Company CPL Private Limited, in which he held all the shares except one, which was held by his wife. You would say that why did he even leave 1 share? The whole point is OPC was not existing at that point of time. He is also the creditor in the company for a certain amount. He also got the insurance of the stock of cotton, but in his own name. Who was the owner of the stock of cotton? The company. He took an insurance, but the insurance was taken in his own name and not in the name of the company. After 1 month, all the stock of the cotton of CPL Private Limited were destroyed by fire. Mr. Sunny filed a claim for such loss with the insurance company. Whether the insurance company is liable to pay the claim? No. insurance can be taken only by the person who has a right over the property. Here Mr. Sunny is not the owner of the cotton. The company is the owner of the cotton. So the rightful person to take the insurance is the company. Since the insurance was taken in the name of Mr. Sunny, it's not a valid insurance. So no, he will not get his money back. Correct? Till now, getting right answers, all of you? An employee, Mr. Karan, signed a contract with his employer company ABC Limited that he will not solicit the customers after leaving the employment from the company. If you remember the name of the case, Guilford Motor Company versus Horn. But after Mr. Karan left ABC Limited, he started up his own company, PQR, and started soliciting the customer of ABC Limited for his own business purpose. So can we say the only purpose his own company was started was to solicit the customers of ABC Limited, correct or not? ABC Limited filed a case against Mr. Karan for breach of the employment contract and for soliciting their customers for own business. Mr. Karan contended that there is a corporate deal between him and his company and he should not be personally held liable for this. In this context, the company ABC Limited seek your advice as to the meaning of and when the wheel can be lifted. So here can we say Mr. Karan and the company will be taken as one? Yes or no? The only purpose the company was incorporated was to solicit the clients of ABC Limited. The wheel can be lifted, and when I say the wheel will be lifted, in this case, what will happen? The company will be restrained from contracting with the clients of ABC Limited. Here they are asking you the meaning of corporate wheel and when then can the wheel be lifted. So basically they are asking you what are the cases where the wheel can be lifted and also explain the concept of corporate wheel. Nice. The answers, you're getting it right. That's amazing. That means conceptually good clarity. A transport company wanted to obtain license for its vehicles but could not obtain license if applied in its own name. It therefore formed a subsidiary company and the application for license was made in the name of the Can I say the only reason the subsidiary company was incorporated was to obtain the license which was not allowed in the company's own name? Yes? So can we say the only purpose this company was incorporated to get that license? Yes. The vehicles were to be transferred to the subsidiary company. Will the parent and the subsidiary company be treated as a separate? No. The court will lift the wheel and consider both of them the same. That means the license will not be granted even to the subsidiary. Because the only reason the subsidiary was formed was because the parent company was not allowed to the parent company was not allowed to get the license in its own name. Mr. Dhruv, I always discuss this question in the class. Mr. Dhruv was appointed as an employee in Sun Moon Timber Private Limited on the condition that if he was to leave his employment, he will not solicit the customers of the company. Again, the name of the case is Guilford Motor Company versus Horn, correct? After some time, he was fired from the company. He set up his own business under proprietorship and undercut Sun Moon Timber Private Limited's prices. On the legal advice from his legal consultant and to refrain from the provisions of breach of contract, he formed a new company under the name Seven Stars Timber Private Limited. In this company, his wife and friend were the sole shareholders. They took over Dhruv's business and continued it. Can we say the only purpose this company was formed was to deal with the clients of Sun Moon Private Limited, Timber Private Limited? Yes. He himself did not become the member of the company but appointed his wife so that tomorrow if there is any dispute, he can always say that this company does not belong to me. Correct or not? Hello, Anu. Correct. So, and as a company, so now what happened? They took over Dhruv's business and continued it. Sun Moon Timber Private Limited files a suit against Seven Stars Timbers Private Limited for violation of contract. Seven Stars Timbers Private Limited argued that the contract was entered between Mr. Dhruv and Sun Moon Timber Private Limited, and as a company has a separate. Seven Stars Timbers Private Limited has not violated the terms. Is it correct? No. The only purpose that this company was formed was to contract with the clients of what was the Sun Moon Private Limited. So the wheel was lifted, same case as Guilford Motor Company versus Honda. Explain the concept of circumstances where the wheel is lifted. So separate legal entity concept is that members in company are different, and when is the wheel lifted? Protection of revenue, where the company is formed for protection of revenue, or the company is a sham or a fraud, or the company is formed to avoid welfare legislations, or to determine the true character of the company, or formation of subsidiary to act as an agent for the company. 5 persons are the only members of a private company. We just did this. Flower Fans Limited. All of them go in a boat on a pleasure trip into an open sea. The boat capsizes and all the 5 die being drowned. Is the private company no longer in existence? I shouldn't write no. It's quite confusing. If I write yes also, if I write no also. So, existence of company remains unaffected. Right? Existence of company remains unaffected. The death of a member does not result in the death of the company because company has perpetual succession. Further, is it correct to say that a company, being an artificial person, cannot own property and cannot sue and be sued? So, well, this all is false. We already discussed these part of the questions also. It's false because a company is a separate person. It has a right to sue in its own name, and it also has a right to own property in its own name. Now we are done with this part of the question. I'm going to start with the next part, which is the types of companies now. No limit private company. I want you all to answer all the questions of the types of company. No limit private company is incorporated as an unlimited company having share capital of 10 lakh. One of its creditors, Mr. Samuel, filed a suit against a shareholder, Mr. Innocent, for so basically the liability is unlimited. And if you remember, I told you in case of an unlimited liability company, the liability of the member is what? It is unlimited. But the liability is not unlimited towards the third party. It is unlimited towards the company. So third party cannot directly go and sue the member. They can sue the company, who can in turn sue the member. But third party cannot directly sue the member. One of the creditors, Mr. Samuel, filed a suit against a shareholder, Mr. Innocent, for recovery of his debt. Mr. Innocent has given his plea in the court that he is not liable as he is just a shareholder. Explain whether Mr. Samuel will be successful in recovering. No. Unlimited liability company, the liability of the member is not unlimited towards the creditor. So the creditor has no right to sue the member. Explain listed and unlisted company. Listed companies are those companies whose securities are listed at the stock exchange, at any one or more stock exchange, provided that such class or class of companies as may be specified shall not be considered as listed company. You don't have to do that much. What is not considered, not there for you. What is an unlisted company? Which is whose securities are not listed. What is the main difference between a guarantee company and a company having a share capital? In case of a guarantee company, the liability to pay the amount is only during winding up, whereas in share capital, it can be either during the course of business or during the winding up of the company. In case of a guarantee company, it may or may not have a share capital. But in case of a limited by shares, it will always, obviously limited by shares, always have a share capital. So these are the two main differences between these two companies. Okay, Mr. A is an Indian citizen and his stay in India during the immediately preceding financial year is for 115 days. He is an Indian citizen, stay in India 115 days. In case of guarantee company, liabilities for the guaranteed amount, whereas in case of limited by shares, guarantees for the liabilities for the unpaid value of the shares. He appoints Mr. B as his nominee, who is a foreign citizen but has stayed in India for 130 days during the immediately preceding financial year. So let's talk about OPC. Whether it is member or whether it is nominee, the rules are obviously the same. Three things. First, natural person. Second, Indian citizen. Third, resident of India. Should he be a natural person? Yes. Should he be an Indian citizen? Yes. Should he be a person resident in India? This is not mandatory. Indian citizenship is mandatory, natural person is mandatory, resident in India is not mandatory. Mr. A first, Mr. A. So is he a natural person? Yes. Indian citizen? Yes. And stays in India for 115 days. So we already saw, and resident in India means what? Who has stayed in India for 120 days. We already saw resident in India is not mandatory. So he is an Indian citizen? Yes. He is a natural person? Yes. So can he open an OPC in India? Yes. Now he appoints Mr. B as his nominee, who is a foreign citizen. Who is a foreign citizen but is he a natural person? Yes. Has stayed in India for 130 days. Is he a person resident in India? Yes. But is he an Indian citizen? No. If you are not an Indian citizen, irrespective of the number of days you stay in India, you are not eligible to be a member or a nominee. Right? Rohan incorporated a one-person company. The memorandum of OPC indicates the name of his brother Vinod as a nominee of the OPC. However, Vinod is starting his new business in abroad and needs to leave India permanently. Due to the fact Vinod is withdrawing his consent of nomination in the said OPC. This fact, taking into consideration, is it mandatory for Vinod to withdraw? No. As long as he is an Indian citizen, irrespective of his stay in India, he can continue to be a nominee. So as long as he is Indian citizen, right? As long as he is an Indian citizen, he can continue to be the nominee. The day he loses his citizenship, then he cannot continue to be the nominee. Can Rohan make his 17-year-old son as a nominee in such a case? You people are giving right answers. That's amazing. Can Rohan make his 17-year-old son minor? A minor cannot be a member or a nominee. So can he appoint? No, absolutely no. Yes, he cannot be a member or a nominee. Mr. R is an Indian citizen and his stay in India during the immediately preceding, he is a Mr. R, he is an Indian citizen. His stay in India is 130 days. He appoints Mr. S, a foreign citizen, as his, so he has an OPC. Can he be a member of an OPC? Yes. He appoints Mr. S, a foreign citizen. Arey Baba, foreign citizen is not allowed irrespective of how many days he is staying in India, as his nominee, who has stayed in India for 125 days during the immediately preceding financial year. Is Mr. R eligible to be to incorporate an OPC? Yes, yes. If yes, can he give the name of Mr. S in the memorandum as his nominee? No. Because Mr. S is a foreign citizen, he is not eligible to open up a OPC. Is it clear? Just give me a minute, guys. Okay, so moving on to the next question. So, Naveen incorporated an OPC, making his sister Navita as a nominee. Navita is leaving India permanently due to her marriage abroad. And because of this fact, due to this fact, she is withdrawing her consent of nomination. If Navita is leaving, is it mandatory for her to withdraw? No, we saw as long as you are an Indian citizen, you can continue to be the nominee even if you are not a resident of India. If Navita maintained the status of resident in India after her marriage, then can she continue? Doesn't It makes no difference whether she maintains her residential status or not. As long as she is an Indian citizen, she can continue to be a member or a nominee of an OPC. Mr. Anil formed an OPC on 16th April for manufacturing electric cars. The turnover of the OPC for the financial year was about 2.25 crores. His friend Sunil wanted to invest in his OPC, so they decided to convert it voluntarily into a private limited company. Can Anil do so? Well, the whole point is that at any given point of time, an OPC can be converted into a private or a public company at any point of time. Yes, it cannot be converted into a Section 8 company. So, yes, he can convert. The concept of dormant company or inactive company has been formed for a future project or to hold any any property, including intellectual property, and has no significant accounting transaction. Significant accounting transactions means any transactions other than this four: payment of fees to the registrar, payment to fulfill the requirements of this act or any other act. Then what was the third one? Allotment of shares to fulfill the requirement of this act, and expenses for the payment for the maintenance of office and records. Anything other than this is significant accounting transactions. ABC Private Limited is a registered company under the Companies Act with a paid up share capital of 35 lakhs and turnover of 2.5 crores. Whether ABC Private Limited can avail the status of a small company? Well, to become a small company, you have two things: 4 crores and 40 crores, not or and, both. Now, there was a lot of confusion regarding this. So, actually, the definition, if you will see in the act, it is given as 50 lakhs and then they have notified it. But ICA is fine even if you write 4 crores directly in the definition also. So, that's also not wrong. Otherwise, you can just write 50 lakh and add it as a footnote. Yes. Yes. So, paid up capital 35 lakhs, turnover 2.5 crores. Is it a small company? Yes. It is a private company. Now, if here, instead of private, if you see ABC Limited, okay, if you see this, don't even calculate or figure out 4 crore, 40 crore. Simple. Since it is a public company, it can never be a small company. Khatam. But it's a private company, so yes, it's a small company, right? What are the significant points of Section 8 companies which are not applicable for other companies? Briefly explain. So, they are formed for any specific purpose. There is no requirement of minimum share. Anyway, this point is actually not so relevant because for no company there is any relevance of minimum capital. They do not they do not distribute dividend. They cannot distribute dividend rather. They have a special license under which they operate. They plow back their whole profits into the business to promote the objects. They don't have to use the word limited or private limited after their names. Rather, they use, association, clubs, words like this in their name. Even a partnership firm can be a member of a Section 8 company. If a company is, if the conditions for which the license are issued are revoked, the license will be revoked. On revocation, the surplus is not given to the members, but it is given to some other Section 8 company, or it is given to, it's transferred to the insolvency and bankruptcy fund. On amalgamation also, it can only amalgamate with another Section 8 company having same objects. Then generally, whenever a company calls a meeting, no, they have to give a 21 days clear days notice. But this company can call a meeting of the shareholders by just giving a 14 days notice. Now, there is no concept of minimum number of directors or independent directors, and there are many committees which are formed, like nomination and remuneration committee. So these companies, they don't have to form such committees. Whether a non-profit organization has to be registered, and if yes, what are the procedures? Yes, they have to, obviously they have to register. So they will have to apply to the central government for a license, and if the central government feels, they will issue a license under Section 8 company. They need not use the word limited, private limited. And on registration, they will enjoy some privileges and obligations. What do you mean by again? Mention the conditions of issue and revocation of license. So basically, if the central government, so basically what is a, so you will write the whole section 8 concept. These companies are formed to promote sports, science, arts, religion, charity, commerce, technology, environment. I don't know why here I cannot see your messages at all. Technology, environment. They do not distribute dividend. They reinvest the profits into the business to promote the objects. They have to apply to the central government for a license. If the license is issued, they don't have to use the word limited or private limited after their name. Even a partnership firm can be a member of such a company, right? Then if the company acts against public interest, acts fraudulently, or acts breaches its objects, or does not fulfill the conditions subject to which the license is issued, the license will be revoked. If the license is revoked, any one of the three, they will either be converted into a private or a public company, or they will have to amalgamate with another section 8 company, or the company can be ordered for winding up. So far so good. Registered under section 8 earned huge profit during the financial year ended due to some favorable policies declared by the and implemented by. Considering the development, some members of the company wanted the company to distribute dividend to the members. They approached you to advise them about the maximum amount of dividend. What? It's a section 8 company. They cannot give dividend. And if they do, license will be revoked. So the members' contention is incorrect. Mike Limited Company incorporated in India, having a liaison office in Singapore. Explain in detail the meaning of foreign company and an analysis on whether Mike Limited will be called a foreign company. A foreign company means a company. A foreign company means a company which has been incorporated. Yes, it's a contravention, correct. Which is incorporated outside India and has a place of business in India. Here, they are incorporated in India and having a place of business outside India, right? So it's just the opposite, right? It's just the opposite. So is it a foreign company? No, Mike Limited is not a foreign company. Correct, guys, correct. Kashish, please follow up why it is not. It's okay even if it is wrong. But did you get the reason why it is not? I hope you got the reason why it is not. Yes. Define OPC and state the rules regarding its membership. Can it be converted into a non-profit company under Section 8? An OPC is a company having only one person as its members. Only a natural person who's an Indian citizen, whether resident in India or otherwise, can be a member or a nominee of an OPC. We take a written consent from the nominee and it is filed with the registrar. Nominee's name is given in the memorandum. Nominee may withdraw his nomination, member may change his nomination, and a person can be a member of only one company and at the same time a nominee of one more other OPC. Minor cannot be a member, they cannot be converted into a section 8. Can they be converted into a private or a public company? Yes, but they cannot be converted into a section 8 company. Parasnath Infra Height Limited is a public company having 215 members. Out of 215 members, 20 members were employees of the company during the period of 1st June to 30th June 23. They were employees. They were allotted shares on 1st April. So this was the period they were employees, right? Now, they were allotted shares. They were allotted shares on 1st April 2017, which are held by them till today, that is till 31st October 2023. Now company wants to convert itself into a private company. State with reasons. Okay, this answer I want you all to give me the answer. Chalo, and then we will discuss it. I want you all to give me the answer and then we will discuss this question. Is the company required Is the company required to reduce the number of members? Not required. Not required. No. No. Okay. So the reason I wanted you guys to give me the answer is, let's look at the provisions. Except, so basically in case of a private company, you need to remember three things are there in the articles. Restricts the number of restricts the transferability of shares, limits the number of members to limits the number of members to 200, and prohibits the RLP, prohibits the issue of securities to the public, right? Now, except in the case of OPC, OPC limits the number of members to 200. Correct? Provided that provided further that persons who are in the employment of the company. Now, I want to show you something. Wait. What was the definition? Clause 68, right? Provided persons who are in the employment of the company, right? So, persons who are the employees of the company are not considered. Agreed. Let's get back here. When were the shares allotted to them? On 1/4/2017, correct? The shares were allotted to them on 1/4/2017. And see, Pramod has just said, he had written the point. I'm so sorry. So, the shares were allotted on 1/4/2017. My first question is, on this day, were they employees? My first question is, on this day, were they employees? Hello guys. On this day, were they employees? No. I told you the period of employment was from here to here. They were employees. See what is given. They were employees during the period of 1st June 2021 to 30th June 2023. So they were employees from here to here. Shares were allotted to them here. On this day, when the shares were allotted to them, were they employees? Not on that day, correct? So, was the share actually allotted to employees? So, were shares allotted to employees on this day? Were shares allotted to employees on this day? Huh? No. So, they will be counted or they will not be counted? Tell me. Exactly, counted. They will be counted. Now tell me if shares were allotted during this period. If shares were allotted during this period, will they be counted then? If instead of here, the shares were allotted in this period frame of time, then in that case, would they be counted? Exactly. Then they would not have been counted. But they were allotted shares before they were employees. So were the shares allotted to the employees? No. So they will be counted or not? Yes, here they will be counted. So did you understand the difference between all the two situations? I hope you've understood. Yes. So are they required to reduce the numbers? Obviously, they have to reduce the numbers. Why? Because the number of members is 215, and in case of private company, the number is 200. If it is 200, should I reduce? Guys, tell me. If it is 200, should I reduce? If it was exactly 200, should I reduce? If it was exactly 200, should I reduce? No. It is up to. See what is given. Limits the number of members to 200. So up to 200 is fine. More than 200, then it is not fine. I asked Nazia that if exactly the number of members is 200, okay? The exact number of members is 200. Then do I need to reduce? Got it? Then do I need to reduce? No. I hope you've understood, all of you. Yes. It is up to 200. If it is more than 200, then I have to reduce. Up to 200, allow. I hope it's clear to everyone. Yes? Yes. Jagannath Oils Limited is a public company and having 220 members, of which 25 members were employees during in the company during the period of 1st April 2006 to, so they were employees during the period of 1st April 2006 to 28th June 2016 or 17, sorry, 16. They were allotted shares in Jagannath Oils Limited first time on 1st July. They were allotted shares on 1st July. Let's take another color pen so that we can actually. So they were allotted first time shares on 1st of They were allotted first time shares on 1st of July 2007, which were sold by them on 1st August 2016. They were employees during this period, right? During this period, they were employees. They were given shares on 1/7/2007, which they sold on 1/8/2016. Then after some time, on 1st December 2016, each of the 25 members acquired shares which they are holding till date. Now company wants to convert itself into a private company. You will tell me whether Jagannath Limited is required to reduce the number of members. You will tell me this. Please tell me, give me the answer to this. That are they required to reduce the number of members? Yes, they have to reduce. Yes. Why? Because the shares were acquired again on this day, and on this day they were not the members of the company. Now they are saying, would your answer, and so there are 225 members, 220 members, so we have 20 members extra, so the numbers have to be reduced. Yes, yes. Now, what would be your answer if they were employees till 28 June 2017? That is, they are saying if they were employees during this period, then what would be your answer? So tell me, what would be your answer if they were employees during this period of time? What would be your answer in that case? Exactly. Not required to reduce. Why? Because then out of 220 members, 25 will not be counted. So the company only has 195 members, which is well within the limits. Yes. Chalo, moving on to the next question. I hope this was clear to everyone. This was the dates. Be very careful if you get a question like this in the exam. Okay? Flora Fauna Limited was registered as a public company. There are 230 members, as noted below. The board of director wants to propose to convert into a private company. Is reduction of number of members necessary? Correct, correct, guys. Very happy to see you are all are giving right answers. Directors and their relatives counted, employees not counted, ex-employees here it's given shares were allotted when they were employees not counted, 5 couples holding shares we already saw joint holders are counted as single members, that means 5, and others are 5. The total number is exactly 200. Do I need to reduce the number? Quickly tell me all of you, do I need to reduce the number in this case? Do I need to reduce the number? Not required to reduce by exactly 200, and if it is more than 200 then there is a requirement of reduction. Correct, up to 200 is allowed. So yes, exactly, correct, correct, correct. A, B and C has decided. I think we are having a very good start to the Christmas is going well. Hope our New Year's are also spent like this only. A, B and C has decided to set up a new club with name ABC Club, having object to promote welfare of Christian society. They plan to do charitable work or social activity for promoting the artwork of economically weaker section of Christian society. The company obtained the status of a Section 8 company and started operating from 1st April 2017 onwards. However, on 30th September 2019, it was observed that ABC Club was violating the objects of its clause, due to which it was granted the status of, okay, discuss the powers. They can revoke the license, and on this revocation, any of the three can happen. They may be ordered to convert into a private or a public company, and if they do so, add private limited or limited after the name, inform the registrar. Second, they may be ordered to amalgamate with another Section 8 company having similar objects. Third, the company may be ordered to be wound up. If the company is ordered to be wound up, whatever surplus is left, that has to be given to another Section 8 company or shall be transferred to insolvency and bankruptcy fund. Yeah, and the teacher will also be doing the same thing with the students. Correct or not, Karnataka? I mean, seriously, what's your name, guys? Like, ऐसे first thing you should do is write your name first in the bracket and then आगे. The teacher will also be doing the same thing with the students, don't worry. Company registered under Section 8 of the Companies Act has been consistently making profits for the past 5 years after a major change in the management structure. Few members contended that they are entitled to receive dividend. I'm not going into this question, we already discussed this. Alpha School started imparting education on 1st April with the sole objective of providing education to children of weaker society, either free of cost or at a very nominal fee depending on the financial condition of their parents. However, on 30th March 2018, it came to the knowledge of the central government that the said school was operating by violating the object clause, due to which it was granted the status of a Section 8 company. Describe what powers can be exercised by the central government. So we already saw the license can be revoked, and when the license is revoked, any one of the three consequences can happen. I am not going into the details again, we've already discussed this. Narendra Motors Limited is a government company. Shah Auto Private Limited is a private company having share capital of 10 crores. So Narendra Motors is a government company. Shah Auto Private Limited, they definitely have a knack of making names. Having a capital of 10 crores in the form of 10 lakh shares. Narendra Motor is holding 10 crores and the shares are 10 lakh shares. Narendra Motor is holding 5 lakh 5,000 shares in Shah Auto. Advise whether Shah Auto is a government company. First of all, to become a government company, your 51% or more of the total paid up share capital must be held either by the central government or the state government or both. Here, nothing of that sort is happening, right? But can I say Shah Auto? Can I say Shah Auto is a Hemant? I am actually not getting your question. As in, it is not necessary. No, resident in India is not necessary. Citizenship in India is necessary. Resident is not necessary. Anyway, so is that condition happening 51% or more? No. But can I say Narendra Motors is holding 5,05,000 shares, which is more than 50% of the paid up of the voting power? Yes, of total voting power, because it is given 10 lakh equity shares and you're holding 5,05,000, so you're holding more than 50% of the total voting power. Yes, you are holding. Now when you are holding more than 50% of the total voting power, that means, can I say this company is a subsidiary of Narendra Motors? Yes. And if you are a subsidiary of a government company, you are also a government company. So, yes, it will be considered as a government company. Hemant, I hope you got the answer. On the basis of control, we have three types of companies: holding, subsidiary, and associate. Citizenship is important. Residency is not important. You may or may not be a resident of India, but citizen of India is mandatory. I'm not going into the definition because when we come to the questions of holding subsidiary, we'll anyway do it. SK Infrastructure Limited has a paid up share capital divided into 6 lakh equity shares of rupees 100 each. 2 lakh equity shares of the company are held by the central government and 1,20,000 is held by the government of Maharashtra. Whether SK Infrastructure can be treated as a government company. It has 6 lakh shares, of which 3,20,000 is held by the government. Correct or not? Can I say 3,20,000 is at least 51% of 6 lakh? Yes. So is it a government company? Yes. ABC Limited has allotted equity shares with voting rights to XYZ worth 15 crores and issued non-convertible debentures worth 40 crores during the financial year 2019-20. After that, the total paid up equity share capital of the company is 100 crores and non-convertible debentures stands at 120 crores. Define the meaning of, okay, associate company. Debentures are never considered because they don't give you business decisions or voting rights, right? Neither you get it. So here you are holding how much? You are holding how much? 15 crores of 100 crores. To become an associate company, at least 20% of total voting power or business decisions. Here it is only 15%. Yes, Hemant, I did make 2 reels actually. So it is not an associate company. ABC Limited has allotted shares with voting worth 15 crores and convertible preference shares. So, what is the basic difference between the previous question and this question? Here it is convertible preference shares. But please understand, unless they are converted, you don't get any voting rights. However, the institute has made 2 answers have been given. So, if I see 100 crores is my capital, 15 crores issued, which is 15%. So, no, you are not an associate company. But here, if you will see, they have made an assumption, important, it can be assumed that convertible preference shares are having voting rights. But actually, unless they are converted, they don't get the voting rights. So you can make that assumption, and in that case, you can say, okay, they are holding more than 20% or more, whatever. But it's not necessary that you have to assume. And you can just simply calculate only equity shares, and that is absolutely correct. Okay. Moving on to the next one. The paid up share capital of RAM Private Limited is 10 crores in the form of 7 lakh equity shares of rupees 100 each and 3 lakh preference shares of rupees 100 each. Lakhan Private Limited is holding 3 lakh equity shares and 3 lakh preference shares in RAM Private Limited. So see, for is it a subsidiary? So please understand, for subsidiary we take total voting power. Preference shares do not give us any voting power, so we don't consider them. So how much equity we have? 7 lakh. And out of this 7 lakh, you need to hold at least more than 50% of total voting power, which should be more than 3,50,000. Here the holding is only 3 lakh. So is it a subsidiary? No. No. Mike Limit LLC incorporated in Singapore, having a liaison office in Pune. So here it's opposite. In the previous case, it was incorporated in India, having a liaison office in Singapore. Here it is incorporated in Singapore and they have an office in Pune. Whether it will be called a foreign company? Yes, incorporated outside India, having a place of business in India. It is a foreign company. Tired now, all of you? Your zeal is gone. Ekdam silent suddenly. Okay. BC Private Limited and its subsidiary KL Private Limited are holding 90,000 and 70,000 shares respectively in PQ. So we have one PQ, we have one BC and we have one KL. What is the relationship between BC and KL? BC is the holding of KL. They are holding 90,000 and 70,000 shares. And what is the total shares? 3 lakh. What is their holding? BC alone is holding 90,000. KL alone 70,000. So if I just take their individual holding, no holding subsidiary. But the definition says either on its own or together with one or more of its subsidiary. Correct? So if I consider that my total holding is 1,60,000, which is more than, oh, okay, enjoying. Kashish, I think the whole point that the class is so late is a little, you are like, okay, I'm getting the feel, that feel that CA kar rahe hum. Nazia, wake up. Good morning. Have water. Okay, so total holding is how much? 1,60,000, which is more than half of 3 lakh, which is more than 1,50,000. So yes, holding subsidiary. So whether PQ is a subsidiary of BC Private Limited? Yes. What would be your answer if KL is holding 1,60,000? Now they are saying KL is holding 1,60,000. That means, can I say KL is the holding of PQ? Yes. BC is not holding anything. But I told you A is equal to B, B is equal to C, therefore A is equal to C. I am your holding, you are their holding, so I am automatically their holding. What would be your answer if the entire 1,60,000 in PQ is held by KL and no shares are held by BC? Still the answer would be the same, right? Kashish is excited about the fact that she's sitting and studying at night where other people are partying, right? You have stories to tell your grandchildren now. That तुमने तो क्या किया, पढ़ाई तो हमने की, रात को 12 बजे, Christmas Eve we have been studying, है ना? Popular Products Limited is a company incorporated in India having a total share capital of 20 crores. It's true. The share capital comprises of 12 lakh equity shares. This was one amazing, crazy question they actually had. We have discussed this question in the class, obviously. 12 lakh equity shares and 8 lakh preference shares. Correct or not? So, Delight Product, Happy Product and Cheerful Product are holding. What, Hemant? I'm telling you the fact. You are creating stories to tell your grandchildren. मतलब imagine foundation level पे ऐसा तो आगे पता नहीं क्या. But they are not saying which type of shares they are holding. So because nothing is, either you can assume that the shares held are equity, which is, not exactly very right to do because nothing has been given. Or you can simply take 20 lakh and the holding is 8,50,000, less than half. But there is a twist in the tail now. Okay. Oh, sorry. And they all are the holdings of subsidiaries of Jovial Limited. So Jovial Limited is holding how much? 8,50,000 shares. But the total share is how much? The total shares are 20 lakh and they are holding only what? They are holding only 8,50,000. So can we say this is holding subsidiary? No. But as I said, there is a twist in the tail now. If now, can Jovial Limited be termed as a subsidiary of Popular Product if it controls the composition of the board of directors of, bro, if you are controlling, how will you be subsidiary? You are the holding, correct or not? It is holding. It is the holding company of Popular Products. I think we are almost nearing the end now. The Articles of Association of XYZ Limited provides that Board of Directors have the authority to issue bonds provided such issue is authorized by the shareholders by a necessary resolution in the general meeting. The company was in dire need of funds and therefore it issued the bonds to Mr. X without passing such resolution. Can Mr. X recover the money from the company? Yes, because it is internal and I'm not required to check the internal management. As an outsider, I just have to check whether the company is allowed to issue bonds or not. How the right was given is not my concern. Indoor management. I think we have already discussed these questions yesterday, if I'm not wrong. We already discussed these questions. So with this, we are done with what do you say? We are done with the whole scanner discussions of the Swiftscan's discussion of Companies Act. The doctrines part we had done yesterday only. Okay, so now we are left with partnership ka discussion and contract act, but I will not be available for the next 1 week. So I mean, I cannot take YouTube sessions for the next 1 week. Obviously, on messages I'll be available. So keep studying, happy learning, stay motivated. There are no amendments. I've already taught all the amendments in the class only. The notes are updated notes. Everything is that is given to you is updated. There are no amendments that you need to follow other than what is given in your material and what has been taught to you in the class. So we have already discussed all the amendments already. So you don't need to, please don't look here and there. You're most welcome, Kashish. So you are not required to look anywhere. Look into the material, look what we have studied. Don't at this point of time, don't panic. Don't look at notes here and there and get all confused because you are hearing people say, oh, the amendments are there, amendments are there. We have already done it. Okay, we have already done it, so you don't have to worry about it. What lecture you want, Nazia, on this? Yes batch. What was this, Hemant? What is yes batch? Oh, acha. You are saying you don't have the amendments. You are saying you don't have the amendments. So the small company limit has been increased from 2 and 20 crores to 4 crores and 40 crores. Okay. And just Hemant, message me. I'll send you the amendments. I'll just send you the LLP, amended notes of LLP. I'll just send you the amended notes of LLP. So that will be okay for you. Okay, Nazia, I'll be back on 31st. So if you want to join the session on that day, I'll just put up a video. If you want to join, that's totally your choice because I don't know at that point of time, would you want to join or not? That's the whole point. I'll just message me, Hemant, I'll send it to you. And anyway, Indian Contract Act, it will hardly take us 1.5 hours. So if you want to spare that much of time, I will do it on 31st. 31st I'm coming. Your exams are starting on 31st only, right? So in that case, if you want, I'll arrange it on that day for that day. Then it's fine, no, if you have it. If you have it, it's fine. Otherwise, I'll send you the notes if you want. Okay? So I'll end the session here. Good night, guys. Merry Christmas to all of you. Okay? If possible, if it's possible for me to record and upload, I'll do it. Otherwise, I'll take a live session on 31st. It's totally your choice. You want to do it or not. You can attend if you want to attend. Okay? So thank you so much. I'll see you all again soon. And keep studying. And this last 1 week, if there will be times when you will be motivated, too demotivated, it's okay. It's absolutely okay, but you remember you've put in so much of hard work. So just keep going. All the best, happy learning, and stay motivated. Bye 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 bye. I'll see you again very soon.